Hello everybody, Phil Snyder with GunClassUtah.com. Hey, today is video number 3 of the Utah Concealed Firearms Permit Course online refresher course for 2024. Today's lesson is going to be the use of force, including the use of deadly force allowed by a private citizen. We're going to go over use of force crimes and assaults, things like that. We're also going to cover private person arrests, also known as citizen's arrest. All of these topics are in your Utah Concealed Firearms course curriculum, and your instructors should have went over these topics in your use of force section. If not, great video to watch here. That's what we're going to cover. We're also going to go over, as the part of use of force, the use of force and deadly force in defense of your habitation, your vehicles, your places of employment, your places of business, your real property and personal property. And first of all, before I start out, I would like to ask the audience a very valid question. Do we shoot to kill, or do we shoot to stop somebody? Think about that for a minute. Commonly, what I get is people say you shoot to kill, and I don't believe that's the right answer. I don't believe that the answer is to have an intention to make sure that our attackers suffer every last breath until they die. That's not our job. If we're involved in a use of force encounter, a use of deadly force encounter that we shoot to neutralize or we shoot to stop our threat. A lot of people ask, well, how many shots are needed? Well, as many shots as is needed if you're using a gun that it takes to stop that threat against your life. If you fire one shot and that person goes down and they are no longer a threat, then that's it. You don't need to do anything else. However, that is probably not going to happen more than likely, and it's a very good chance that it might take more than one shot. And so it's not like these old Western movies where you see somebody get shot and they just immediately fall to the ground. The second thing you want to ask yourself when you're using force and you're going to start carrying a gun is if you have any moral or religious or other reasons that would prevent you from taking a human life if it was necessary in self-defense. A lot of people haven't thought about that when they start carrying a gun, and that can be a serious problem if you're faced with a deadly force threat and you haven't had that conversation with yourself in your mind. So let's get into this. I'm going to go over the statutes. I'm going to cite the title of the code, and I would really strongly recommend that you pause the video in between these lessons and read these statutes word for word. And then when you have done that, you can come back to the video and I will give you the short version and explain this in a little bit more detail. But the first statute, Utah Title 76-2-402, and you go to a website, I apologize, you go to a website, it's LE as in Lima Echo .utah.gov, G-O-V, le.utah.gov. Click on the section that says code, and then there's a search bar, and then you can push in, and then you can enter in that title, 76-2-402, and you will see that it says force and deadly force in defense of a person. This was last revised May 2022. And it says a person is justified in protecting yourself and others against the imminent use of unlawful force against you or anybody else that you reasonably believe is necessary to protect you or that third person. So the law not only allows you to protect yourself and obviously your loved ones and friends and family members, but other individuals as well. The force or the threatened force, it must be unlawful, And it must be an immediate threat to you. So this is going on right now. This isn't, a threat that somebody made and, they said that they were going to meet you after work and kick your ass. Okay, this is right now. So they're either assaulting you or they're up in your face or something like that. The force that you use to protect yourself must be reasonable. Reasonable is what a reasonable, prudent person would do given your set of circumstances. Being placed in your shoes, knowing everything that you knew at the time. You are only justified in using deadly force, and the definition of deadly force is force which is intended or likely to cause death or serious bodily injury only if you reasonably believe that your life or somebody else's life is in immediate danger of serious bodily injury or death, or to prevent the commission of any forcible felony. Now let's talk about what a forcible felony is. The following crimes are forcible felonies: aggravated assault, mayhem, aggravated murder, manslaughter, kidnapping, aggravated kidnapping, rape, forcible sodomy, rape of a child, object rape of a child, sexual abuse of a child, aggravated sexual abuse of a child, aggravated sexual assault, arson, robbery, and burglary, and any other offense that poses a risk of death or serious bodily injury. The legislature notes that unoccupied vehicle burglaries are not a forcible felony. That would be a vehicle burglary, which would be a Class A misdemeanor in the state of Utah, and that is not included. We talked about serious bodily injury being a required element and a required level of a threat in order to respond with deadly force. And so here is Utah's definition of serious bodily injury, and you can find this under Title 76-1-101.5 as amended 227 of 2023. Serious bodily injury means bodily injury that creates or causes serious permanent disfigurement, protracted loss or impairment of the function of any bodily member or organ, or creates substantial risk of death. If there are any doctors on the channel listening, please comment and give us a definition of serious bodily injury and give us an idea that we can visualize on what type of injury that would be. I would imagine that if you had a concussion or if you had a major broken bone, such as a femur, that would probably be a serious bodily injury. But I would love for a doctor to give a medical opinion on that. You won't be found justified in using force and deadly force if three things exist. If you are found to have initially provoked the encounter, to use that as an excuse to inflict bodily harm on somebody, or if you are involved in felony crime, so you're attempting to commit a felony, you're in the act of committing one, or you're fleeing the commission of a felony crime, and you use force during this felony crime that you're doing, you're not going to be found justified. Or if your attacker or that other person withdraws from the encounter, so they have to clearly and effectively communicate their intent to withdraw from the encounter. So they say, hey, okay, stop. And then, they turn to, run away from you. If those exist, you would not be found justified. And when our adrenaline gets going and it takes over our body, I've seen this in law enforcement a lot. Road rages, for example, people's adrenaline gets going and maybe they were threatened in a road rage, and then maybe that other person escapes and you pursue them when that danger is over with. Now you're setting yourself up for some jail time if you're found not to be justified in doing something that you are doing after that window of self-defense has been closed. Utah is a no duty to retreat state. As long as you have entered and remained in a place that you have a legal right to be, There is no duty to retreat. However, I would retreat if it was feasible to do so and it didn't make it more dangerous for me to do that. That would be something that I would do. I'm only going to use a firearm as a tool of last resort. And if I had an easy way to get out of that situation without making it worse, I would do it. Your use of force case is ever reviewed and you are seen as trying to retreat from that situation, even if it's just, backing up from your attacker, trying to get distance and giving them verbal commands to, hey, stop, things like that. That goes a long way when they are examining your use of force by a prosecutor. It shows that you are being reasonable and that you try to avoid the situation. Let me give you a definition of robbery because they're very common forcible felonies. Utah Title 76-6-301. Robbery, in short, is unlawful and intentional taking of property in possession of or immediate presence by means of force or fear. So they use force or fear to take that property from you. For example, a carjacking would be a robbery. You are in the vehicle and they open your door and they threaten you and they say, get out of your car, I'm stealing your car. That would be a carjacking. Or if they use force or a threat of immediate force, or they instill fear in you during the commission of a theft, that would also be a robbery. So let's say that somebody does a beer run at the 7-Eleven and the cashier goes out to chase them and that person turns around and punches them in the face and runs away with the beer. Now that misdemeanor theft turns into a robbery, something that I saw quite commonly in patrol. Another common forcible felony are burglaries, burglary of homes specifically. Utah Title 76-6-202. The definition of a burglary is entering or remaining unlawfully in any building or home with an intent to commit any felony, any theft, any assault on any person, any act of lewdness or voyeurism or sexual battery. They don't need to commit those crimes in order for it to be a burglary. They just have to intent has to be shown by a prosecutor to convict them of a burglary crime. And then, of course, any crime that they did commit would be an added charge for prosecution. Now, before we get into the aggravated assault statute, I just want to talk about drawing a gun on people. Okay? I'm going to empty my gun here. All right, gun is clear. So if you are ever threatened by somebody and if you are going to draw a gun, you would need to be able to articulate a fear, a reasonable fear of death or serious bodily injury, or you are preventing the commission of a forcible felony in order to draw that gun on somebody. And so when you draw the gun, we teach this in the Utah class. Your instructor should have talked to you about this already. When you draw, when you're not ready to fire, you never point a gun at somebody. It's down here at the low ready. And low ready is it's about a 45-degree angle at the ground. And it's not pointing at the person that's threatening you. It's just at the base of the front of their feet right there. It's just right out in front of them. Another thing the NRA teaches is this retention ready. And this is, this doesn't make your arms so tired if you had to do this for a while. Maybe you found somebody in your home when you were waiting for police to respond. I can hold like this all day and my arms don't get tired. So whether it's retention ready or it's low ready, this is where you should be when you're drawing a gun and you're not quite ready to fire yet. Coming out of the holster like this is a big deal, right? But, maybe this gun comes out and you got time to give them a warning or something like that and tell them to drop that knife or whatever it is and give them a chance to respond. If they drop that weapon or whatever that perceived threat is and they cease their hostile actions, then you can come back into the holster. So just remember that. You never come up here on high ready, or they call this combat ready, unless you're going to fire. Let me tell you a story about a road rage that happened in Magna, Utah. This was several years ago when I worked for the Unified Police Department. I was working patrol, and there was a road rage over a parking stall. These two men lived in this apartment building, and there was a bunch of cars parked in there, and it was, managed poorly, and they just had too many cars there. And this guy pulled into this parking stall, and this concealed carry holder got upset and blocked this guy in and went up and, rapped on his car window. "Hey, you need to move your car right now, bud." And the guy said, "Why?" And he goes, "Well, that's my parking stall. Move it." And the guy in the car said, "No, this is guest parking. Anybody can park here. You go park somewhere else." Anyway, this escalated and it went back and forth. And the guy in the car was very patient with this guy in the beginning. And he just kept saying, "Leave me alone, go away, and get out of my space." Well, the guy wouldn't listen. So the guy got out of the car, the victim, and he gets up in this guy's face, and they're, yelling at each other back and forth. And the guy that got out of the car, the victim, said, "Get the hell out of here, I'm going to beat your ass." The guy draws the gun. "Get back right now, get back," and points this gun at his chest. The guy was just visibly shaken when I got there, and he wanted to press charges against this guy. So I located this suspect that did this, got his phone number, and I called him and I asked him to come outside and talk with me and just leave his gun in the home. So he came out and I repeated what was said, and I asked him to give me his side of the story. I said, "Why did you point the gun at that guy?" He says, "I was in fear of my life, sir." Those are really good words to say, but if the cop doesn't buy off on it, they're going to ask you more detail about what happened, which I did. I said, "Well, what did that other person do to cause you to be in fear of your life?" And he said, "Well, he threatened to kick my ass. That's assault. And you saw the size on that guy. That guy had like 50 pounds on me, and I thought he was going to clobber me." And I said, "Well, verbal words saying I'm going to kick your ass, number one, is not a crime. There was no other show of immediate force that went along with that threat. For example, he didn't cock a fist back as he was saying he was going to kick your ass. So you really had no crime to defend yourself against. And also, it appears to me that you provoked this whole thing. You had no legal right to even walk up on this guy and talk to him." So anyway, I asked him, and expect this to happen to you if you draw a gun on somebody and it's a questionable thing. I said, "Was your finger on the trigger when you had that gun pointed at his chest?" He says, "I don't remember." I said, was your chamber loaded?" He said, "Yeah, I always carry one in the pipe." I said, "See, you had a gun pointed at somebody when you yourself admitted you weren't even ready to fire yet. How easily could that gun have gone off and killed this person during this move that you made?" Anyway, I put him in handcuffs and I took him to jail. And on the way to the jail, I told him, I said, why didn't you just point the gun at the low ready?" And he said, "What's low ready?" I said, "Well, you got a concealed firearm permit. Your instructor should have told you what that means." He didn't know what it meant. I said, "Low ready is when you're at a 45-degree angle at the ground." I said, "Had you done that, I would have charged you with a misdemeanor, with a Class A misdemeanor, brandishing, drawing a weapon in a fight or a quarrel." Anyway, when I left the jail, I submitted my report to the district attorney's office, and they agreed that that was the appropriate charge, and they prosecuted this guy for aggravated assault. It's a violent felony. He lost his gun rights for the rest of his life over a bad decision that he made. There's a big difference between drawing down here at the low ready and not pointing it at somebody and not having your finger on the trigger. You look like you know what you're doing in front of a camera if you ever recorded. Big difference between that and now when you're pointing it at somebody like this. It makes the risk of somebody being harmed more, and depending on the officer's discretion, it could make the difference between a misdemeanor charge and a felony charge if drawing that gun was viewed in the officer's opinion or the DA's opinion as being unlawful. Utah Title 76-5-103, aggravated assault. This is one of those forcible felonies. That's a very popular crime. If you're going to start carrying concealed, this is a very good chance, if you are going to be a victim of a violent crime, that this will happen, could happen. As amended July 1st, 2024. Aggravated assault is either an unlawful attempt to cause bodily injury to somebody, or an unlawful act that causes bodily injury, or creates a substantial risk of bodily injury, or a threat accompanied by a show of immediate force to do bodily injury, and it must include either the use of any dangerous weapon, so it could be a gun or a knife or a baseball bat or a rock or anything by either its design or its manner of its use that can cause serious bodily injury or death. So it has to include that dangerous weapon, or the Utah legislature included vehicles in here as a dangerous weapon, and any chokeholds or strangulation, anything like that that is intended to impede the breathing of the circulation, or is intended to produce a loss of consciousness, things like that. That would be your aggravated assault. We've had a lot of media cases I've seen in Utah and other places where people are now deliberately trying to run over pedestrians crossing the street. And I think it's such a problem. And also, officers, people are trying to run over officers in their vehicles. And it wasn't really specified in the law. And so the legislature has felt that important to include that in there. Let me talk about another use of force that gets a lot of people in trouble. Utah Title 76-10-506. It's called threatening with or using a dangerous weapon in a fight or a quarrel, nicknamed brandishing, as amended May 4th of 2019. I typically would see a lot of brandishings in road rages or, bar fights, something like that. Somebody pulls out a knife or something during some sort of a verbal altercation, had a little bit too much to drink. Not the best judgment during those times. But the elements of this charge are, in a fight or a quarrel, they draw or exhibit a dangerous weapon. Okay? So it's either, that drawing that gun, or, maybe they're just exhibiting, showing this dangerous weapon to somebody. In an angry and threatening manner, and in the presence of two or more individuals. So if I brandished a gun to you, you would be one person, a victim, but there would need to be another person as a witness to that. And if there wasn't, it would not meet the required elements of brandishing, but that could be aggravated assault if they wanted to go that route as well. There is a defense to this charge if you reasonably believe the action was necessary under this use of force statute, defense of persons. So let's say that somebody has threatened to, kick your ass, and, they got their fist clenched, and they're like, "Come on, mother effer," and they're approaching you aggressively. And depending on your abilities, you draw that gun down here at the low ready on them. Well, that sounds like something that a reasonable person would do if they didn't have any other means to defend themselves. Now, Bruce Lee or Chuck Norris back in the day, they wouldn't feel like they would need a gun. They probably just roundhouse them and, knock them out cold. But, if you don't have those kind of skills or something like that, or, you're a woman and, you're facing a man attacker, that gun coming out sounds pretty reasonable. But here's the other thing. Just because you draw a gun on somebody, that might not scare them every time. And they may just want to take that gun away out of your hand and rip it out of your hand and use it against you. So you need to have the mindset to be prepared for that. And how serious of a crime would it be if somebody tried to physically disarm you and take your gun, whether it's out of your holster against your will, or rip it out of your hand when you're doing it under lawful self-defense? That would be the crime of robbery, and that would be a forcible felony. Utah Title 76-2-405, force and deadly force in defense of your habitation. This was one they changed as amended May 1st of 2024. It says an actor is justified in using force you reasonably believe is necessary to prevent or terminate unlawful entry into or an attack upon your habitation, your vehicle, your place of business, or your place of employment. Part of the changes they made to the statute this year, they have included vehicles, your place of business, your place of employment as extensions to your habitation. Deadly force is justified to protect these areas only if the entry or the attempted entry is made in a violent and tumultuous manner, surreptitiously or by stealth, and you reasonably believe the purpose of their entry is made or attempted to perpetrate personal violence and assault or worse to you or anybody else in the home, and that the force is necessary. Now let's talk about the other changes that the legislature made to this statute this year. Prior to this change, it was 1984. And so it went about 40 years before the legislature started messing around with this statute. And if you want to read the bill, I encourage you to do it. It's Utah House Bill 369. And if you notice, under paragraph 2B, I believe it is, if you look in the bill, look at the old version, they've crossed out these words, reasonably believe, and making the use of deadly force necessary, under paragraph 2. Also, they made little changes. I don't know if it makes a big deal or not, but it used to say you reasonably believe that they were going to offer personal violence, and they've crossed out offer and they put the word perpetrate personal violence. Why? Some people believe that Utah is moving towards a necessary standard when it comes to the use of deadly force instead of the old reasonable standard. Necessary standard is a much higher bar to raise. You decide. You read it. You decide. The presumption of reasonableness for vehicles, business, and employment locations for purpose of civil and criminal cases is if the entry or attempted entry was unlawful and they removed or attempted to remove you, or entry or attempted entry was made into those areas, again, that vehicle, business, or employment, by use of force, and you were not yourself provoking the encounter or involved in a criminal offense yourself other than a traffic violation. Now let's talk about how they've added these three areas as extensions to your home and how that would apply. So if vehicles are included, and let's say that there's a road rage situation that you didn't cause, and let's say that somebody was trying to hurt you and blocked you in and you had nowhere to go, and let's say that if somebody was pounding on your window trying to break in to rip you out of your vehicle while they were making threats to kick your ass, is that not a violent, tumultuous entry of that extension to your home? Is that going to cause you to be in fear of personal violence or worse? If the answer is yes, then that might be a situation where if you have no other options, you might be using deadly force. This year, the legislature also created House Bill 84, which requires all K through 12 schools to have either a school resource officer, an armed security guard, or a volunteer school guardian, like a teacher, if the school has 100 employees or less, or a principal or a lunch lady or a janitor, some other volunteer that goes through about 24 hours of training and is asked to step up in these deadly threats if they volunteer to do so. One thing about the school guardians, I have another video on that, you can watch that. The school guardians do not have qualified immunity like police officers do, and they should. And if I was a guardian for a school, I wouldn't even volunteer to do it unless I had that qualified immunity. And what qualified immunity means is, if you are following the policy of your work and you are following state law and you act in good faith, you can't be sued or you can't be charged criminally. School guardians also shall write a report if they ever point a gun at a student or somebody else, whether you're in the right or the wrong. You have to incriminate yourself and write a report justifying your actions. And one other thing to think about if you're going to be a school guardian, because places of employment are considered extensions of your home, and if they're covered under defensive habitation, then if you respond to a school shooter as a school guardian, you would be examined under the defensive habitation statute. And if you believe that after these changes have been made, that use of deadly force should be necessary, that might be another concern as well. Now, the presumption for your defensive habitation now, just talking about the home, for the purpose of civil and criminal cases is if the unlawful entry or attempted entry was made in a violent, tumultuous manner, surreptitiously or by stealth, or you had that reasonable belief that they were going to commit a felony in your habitation, there is a presumption that your actions were reasonable and would be justified. But, presumptions can always be rebutted. It's not a guarantee. It's just if those conditions are present and there's no other evidence to the contrary, then there's a presumption of reasonableness. Now let's talk about 76-2-406, force in defense of property. So this is things that can be replaced. Unoccupied vehicle burglaries would be under this statute, or they steal a bicycle out of your yard, or they graffiti your fence, or they're vandalizing your car with a key or something like that. Things. It says you are justified in using force that you reasonably believe is necessary, except deadly force, to protect your property if it's lawfully in your possession or lawfully in the possession of a member of your immediate family, or if you're a security guard or you're a police officer and you have some legal duty to protect the property. You can under this law, but you can never use deadly force or a threat of deadly force to protect your things. And the presumption of reasonableness when you're using force to protect your things and your property, the value of the property. So obviously, if they steal your car, versus, stealing a $2 Bic lighter, that's going to make a difference. Prior threats made or history with persons interfering with your property would be factors in determining your reasonableness. So let's say that you get the proverbial car burglary at 2 o'clock in the morning. You look out your window, the dogs are barking, you see somebody rifling through your car, trying to steal things out of your car. Can you go out to the car and confront them? Get on the ground right now, I'm calling the cops. Probably not, because that is a threat of deadly force. Even though you didn't shoot them, that is still a threat. And we talked about earlier, you need an imminent threat of death or serious bodily injury to do that. So unless you can articulate that that's why you're drawing that gun, for example, that car burglar escalated that situation when you went out there, that would be the only way that would change. 76-2-407, use of deadly force in defense of persons on real property, as amended May 1st, 2024. Another one they changed. An actor is justified in the use of deadly force of defense of persons on real property only if you are in lawful possession of the real property, you reasonably believe the force is necessary to prevent or terminate the trespass onto the real property. The trespass is made by force or in a violent, tumultuous manner, and one of these two. You reasonably believe the trespass or attempted trespass is made for the purpose of committing violence to any person or a reasonable belief that they are committing any forcible felony that poses imminent peril of death or serious bodily injury, and the use of deadly force is necessary. Now, the reason I held up my fingers is because you need all of these elements present if you are going to be deploying deadly force for defense of persons on your land. You can't just shoot a trespasser because they hop over your fence at 2 o'clock in the morning and they're looking around in your yard. As a law enforcement officer working patrol for about 18 years, I've never seen one of these. And so you got to be really careful with this. If there's somebody's out in my yard, I think I'm just going to stay in my house and call 911 and let the popo deal with these folks. I'm not sure if it's really going to be worth it or not in most cases, but you know, there might be some cases where it is. The changes that they made to this statute we just read, number one, the old version would allow you to threaten or use deadly force to prevent the commission of any forcible felony. And now they've restricted it to using deadly force only to prevent commission of the forcible felony that pose imminent peril of death or serious bodily injury. And if you look at the bill, they have crossed out words reasonably believe, leaving it necessary when you're using deadly force. So again, if you watch this whole video so far, is the state of Utah leaning towards using deadly force, making it necessary, versus the old version of reasonable? You decide. Title 76-8-512. Impersonating a peace officer, as amended this year, May 1st, 2024. If a person impersonates, displays a badge, ID card, uniform restraint device from a governmental entity without authority, so a police department, for example, or they make a statement they are a peace officer or public servant with intent to deceive them or to get them to submit to that pretended authority, that would be a Class B misdemeanor. Part of your course is to talk about the citizen's arrest, also known as arrest by private persons. Utah Title 77-7-3, arrest by private persons, last amended 1980. If you're a security guard or somebody like that, it's good to know what the law is, but your company policy at your security company is going to direct you on this. I know a lot of security companies, they don't want you making these arrests, but if you were a security guard and your company allowed you to do this, if it was consistent with state law, pay attention, and we'll tell you what the code is, and you know, you can read this for yourself as well at that website we mentioned earlier. I think the statute is way too overbroad, and you know, usually a security guard or you know, a loss prevention officer, somebody like that, is going to be making these types of arrests because they don't have peace officer powers. However, I have seen, you know, private persons make citizens arrests. Typically, you know, you see somebody breaking into your car that's unoccupied, and you know, I've seen them holding them down, waiting for me to arrive as a cop to, you know, take him into custody, and then they fill out a witness statement and they sign the citation. Or maybe they're preventing an assault or something like that. Maybe they witness somebody getting beat up and they intervene, or somebody assaults them and, you know, they protect themselves and they hold that person down for the police arrived. But they're kind of rare to do. And, you know, to be honest with you, I'd probably kind of shy away from this because, you know, there have been cases of cops charging people with kidnapping for doing these unlawfully. And so you really got to know what you're doing. But a private person can arrest another for any public offense committed or attempted in their presence. So you have to have witnessed the crime. Or when a felony has been committed and you have reasonable cause to believe the person has committed that felony. Arrest defined. Last amended 1980. The definition of an arrest is an actual restraint of another person or submission to custody. No more restraint should be used than is necessary. So for example, if I saw somebody, let's say that I saw somebody beat somebody up, and I intervened in that situation, and I separated these two, and I told this person, hey, I want you to sit down right here. I'm detaining you for the police to arrive. And if they're calm and they're compliant, I don't need to do anything else because no more restraint than is necessary. The use of deadly force to make citizens arrest is never allowed. So again, if you draw a gun on somebody because you want to hold them there for the police under the Citizens of Arrest law, you're not allowed to use any threat of deadly force or any deadly force. Manner of making an arrest as amended May 9th, 2027. This is Utah Title 77-7-6. Notice shall be given of your intent, cause, and authority to make the arrest. For example, hey bud, I saw you break into my car and I am making a citizen's arrest and I want you to stay right there until the police arrive. I'm calling them right now. However, giving notice is not required if giving notice will endanger the life or safety of anybody or will enable that person to escape, or they're engaged in the commission or attempted commission of a crime, or they're being pursued immediately after committing the offense. Utah Title 77-7-7. Force in making an arrest. After the person has been informed that they are under this private person arrest and they flee or forcibly resist after telling them, you could use reasonable force to effect that arrest. Again, no deadly force can be used. Now let's talk about this. Should you make a private person arrest? Is the suspect's identity known? And is the crime minor? You could just be a good witness and report this to the police. That's what they prefer you do anyway. Is there some compelling reason that you need to keep them on scene and risk your life and others' lives to detain them for the police? Think about that. There must be a very compelling reason to keep them there. Maybe they broke into your house. You went down in the basement to investigate a noise. And you had your gun out investigating that noise, and you saw somebody down there going into your kid's bedroom, and you've got them at gunpoint while the cops are coming. All right, that's a good citizen's arrest. You witnessed the crime, and it's a very serious deal. It's a burglary. It's a forcible felony. Just use good judgment. We don't want to lose this privilege. This is a very powerful privilege that private persons and concealed firearm permit holders have. And we don't want to have this taken away by the legislature because of some bad press stories about somebody not using good common sense. Let's talk about assaults. Utah Title 76-5-102 as amended May 4th, 2022. An assault would be, you're going to hear similar elements to aggravated assault, right? An attempt or an act with unlawful force or violence that creates bodily injury. So let's say that somebody, swings at you and you duck and they miss, or they connect that punch. It's still an assault, whether they connect it or not. Or they do some sort of unlawful force that creates a risk of bodily injury, and that would be a Class B misdemeanor. So, you're typically slapping and punching and kicking and, shoving people around to the ground. That would be your misdemeanor level assaults. Assaults rise to a Class A misdemeanor if it causes substantial bodily injury. And that definition would be bodily injury not amounting to serious bodily injury that creates or causes protracted physical pain, temporary disfigurement, or temporary loss or impairment of the function of any bodily member or organ. I always say that wrong. Or if you assault a pregnant woman that you have knowledge of the pregnancy, that would be a Class A misdemeanor. Utah Title 76-5-107, threat of violence. Effective May 1st, 2024. Here's another one for your update. Sexual offenses have been added to this statute. So a threat of violence is when they threaten to commit any sexual offense under 76-5-4. So for example, they say, hey, I think I'm going to rape you. Or they threaten to commit any offense involving bodily injury, death, or substantial property damage. Or they make a threat accompanied by a show of immediate force to do bodily injury, and they acted with intent to place that person in imminent fear of those offenses being committed. That would be another use of force crime. And there's no defense to that crime that the suspect did not actually carry it out, or that they were incapable of carrying it out. Just because the words of the threats and the intent to cause you to be in imminent fear would be enough for this. So let's say that a suspect approaches a woman on a walking trail. We've had women that have been killed on walking trails, and they're alone and there's nobody else around. Let's say it's getting dark and somebody approaches them and they make a threat that, they're going to sexually assault them or something like that. And, they're doing that with an intention to cause them to be in imminent fear of being sexually assaulted. Well, that is a use of force. Now, if a woman or somebody else is involved in a situation like that, would it be reasonable for that woman to draw a gun on that person? Whenever you're involved in a use of force case, you always have the risk, even though you have the best intentions, of being not only criminally charged, but civilly sued as well. And O.J. Simpson was a good case that, most of us remember back in the 90s. He was arrested for murdering his wife. And the LAPD recovered some evidence of the scene, including a pair of leather gloves. And so during the trial, he had some high-powered lawyers that put on a really good case for him. And they had OJ try on these gloves that recovered at the crime scene. They were way too small for his hands, and he just was trying to stretch them and get them onto his hands. And that created enough reasonable doubt to acquit him of the murder charge. So in criminal cases, those are the cases that are the hardest to prove. They have the highest burden of proof. And that is, the prosecutor has to create reasonable doubt in order to convict somebody. A defense attorney would need to create that reasonable doubt in order for their client to be acquitted. But what happened was, the family of Mr. Simpson's deceased wife filed a lawsuit against him for a civil lawsuit, wrongful death, and they won. In civil cases, they're not as hard to prove. It's called a preponderance of the evidence. Preponderance means the weight of the evidence. And so imagine a pair of scales sitting here, and one side puts facts over here, presents facts to the court, the other side presents their facts. And it just takes those scales tipping over here, the more weight on this party's side to win that case. Fortunately, in this good state of Utah, they have laws that protect us users of force against criminal and civil trials and cases under self-defense. The first one is 78B-3-110, Defense to Civil Action for Damages Resulting from Commission of a Crime. It says, victims of crimes cannot be sued for personal injury, disability, or wrongful death lawsuits if the suspect entered the victim's property with criminal intent or was a victim of a crime. And this applies to victims' immediate family members as well. However, You would not be covered, and this section would not apply to protect you if the suspect, can prove with clear and convincing evidence that their actions against the victim did not constitute a crime, or if they clearly and effectively retreated from the activity. Another good law that was passed, 2021, I believe it was May, justification hearings, Utah Title 76-2-309. Florida and Utah are the only states that have this privilege. What it says is, if you are a user of force and you have a prosecutor that wants to charge you criminally for an act of self-defense that you did, has to be a Class A misdemeanor or higher, the charge that you're looking at. So for example, that brandishing charge, or maybe you shot and killed somebody, doing a home invasion on your home, these would be serious enough crimes to get you that self-defense hearing. But the prosecutor under these has to show with clear and convincing evidence that your actions were not self-defense. So it's their burden, not ours, to show that to a judge. If the prosecutor cannot convince the judge of that, and those charges have to be dismissed with prejudice, which means they can't be refiled later. That means that situation has been reviewed in front of a judge and they've determined that you were justified. And it goes bye-bye. If the prosecutor prevails, then they have the green light. Now they can criminally prosecute you if they'd like to. The prosecutor, even if they prevail in the case, they are not allowed to bring up any mention of a self-defense hearing in front of a jury. And so it essentially makes their work start all over again. But this is a really good, important law to have. And I know that some prosecutors aren't happy with this, and we might want to watch this every year and see if they try to change this. But I've heard prosecutors actually say that it creates more work for their office to go after people defending themselves. But I like having that extra bite at the apple in self-defense cases. Here's some helpful last tips, and then we're going to end the video. Remember, if you're ever involved in a use of force case, you always want to try to be the first one to call 911 and identify yourself. I'm the victim. I'm the witness. Remember, those 911 lines are recorded and they can be used in court against you. So you need to be careful what you say. Officers have body cams. Most of them do. Most departments have a policy that those body cams are to be activated during citizen contact. So you're probably going to be recorded, everything you say. That can be used in court against you. Get an attorney right away if you're facing a use of force case, even if you feel like it's justified. Those are very traumatic experiences that you go through, and you're probably not going to be able to put a coherent story together after something serious happens due to the trauma that you're going through. Have them respond to the scene if you can. Reach out to us if you're involved in something. We could probably recommend a good attorney for you. If you don't have a lot of income, the courts, at least here in Utah, and I'm sure it's pretty standard across the U.S., you can get a public defender if you have low income and you have a lot of dependents, things like that. You can have a public defender represent you. Avoid having a gun in your hand when you're contacted by the police. If you can have that gun holstered, if it's safe to do so, do that. And have good communication with the officers when they respond. If you shot somebody in a parking lot, have your hands up high. Hey, I'm the victim. I'm the one that called, sir. Don't reach for any weapons. Remain on the scene if it's safe to do so. You look guilty when you leave the scene, but you might have to leave a scene, and that's okay. You can explain that. Exercise your Fifth Amendment to remain silent and have an attorney represent you before answering questions, but be super nice to the officers. Don't be a jerk and don't be rude, or you just might go to jail anyway. Sir, ma'am, I've been through a lot. I'd like to call my attorney and before answering any questions and to have him here with me. Would that be all right? It's going to go a long way. How much do you say? I'm not a lawyer, but when I was involved in a deadly force encounter, when I worked patrol, when a guy started shooting at me on a man with a gun call, and the guy was neutralized at the end of the day, I was very limited in what I said. The chief came up and he asked me what happened, and I just basically said, hey, as you heard over the radio, we were being shot at. We had to take steps to defend our lives. The suspect's been neutralized. He's in the ambulance. Sir, here's all the bullet casings out here in the road. I was pointing out the evidence to him, and it was in a residential neighborhood, and I said, sir, I'll tell you that, several rounds were shot in this direction. Several rounds were shot in this direction. And then I shut my mouth. And he wanted to ask me more questions. And I said, sir, with all due respect, I've been through a lot right now. Got my attorney en route. Would it be all right if I waited for my attorney to come here with me while I'm being questioned? And then I was sent home on paid administrative leave. And I had a homicide detective call me while I was at home for about 6 weeks on paid administrative leave with these other 2 officers that were involved in their doing. And I had to decline again to talk to the detectives to come in for a statement. So they will try to talk to you. It might not just be on scene, but you might get phone calls or to come in and go to the police station for an interview or visits to your house. But if you're doing that voluntarily on your own. You're protected by the Fifth Amendment. Also, one thing that people don't think about. If you're involved in a use of force situation and you're really upset and, you call your dear mother or your dear girlfriend or your brother or sister or somebody like that, and you start telling them everything that happened because you're upset, those people can be called into court as witnesses under a subpoena to testify against you about what you said. And the only exception is spousal privilege. So if, your spouse cannot be compelled to testify against you, check with your lawyer on that. But in Utah, that was the case. But, anybody else is fair game. So probably better just to only be doing the talking to your attorney because that's a protected privilege between the attorney and the client, and ask any lawyer what the mistakes that their clients make. And they'll probably tell you, I wish my client would have shut their mouth and just let me do the talking. Here's another thing. If you're involved in a situation, if it involves your gun, you're going to have that gun taken away on the scene. If it's at a house, they're going to want to see it. Don't put it in your gun safe with your other 50 guns in your collection. You might get them all taken during a search warrant. If this was in your house, you could just set the gun on the table in the living room where this happened. Sir, ma'am, the gun's right over there. And then, they don't really have any probable cause or reason to, go in the back of your house and in your gun room and look in your gun safe. They need to do those ballistic tests, okay? So let's say that there's 9mm shells around this person that broke into your home, and that's a 9mm handgun. Well, sounds reasonable that they just take that gun. They don't need to do anything else. But there's no guarantee. You don't have to consent to searches either. That's your Fourth Amendment protection. Now, in a situation like this, I advise that you just hand over the gun. But if they take it without a warrant, there's going to be issues with that. That's called fruits of the poisonous tree. So they're going to get a warrant and they're going to get it whether you like it or not. So just hand it over. But you don't have to consent to any searches. If your gun is taken, request to the officer that, number one, you get a receipt for the gun. And number two, you request to the officer and ask them to put it in the report that you would like the gun returned when the case has been adjudicated. So let's say that the prosecutor sends you a written letter that says you're justified, you should be able to get it back then. Or if it goes to court for a trial when you're acquitted, then you could get it back. And so you want to find out who that case manager, or usually a detective in these situations, so you have a point of contact with your case number. And all the case manager has to do is sign a written authorization, and they give that to the evidence room, and then you can go and pick that up. This concludes my use of force updates for 2024. This is video 3 of 3. I probably have about 2 or 3 other ones to do to complete the complete online refresher course, and they will be in a playlist. So feel free to watch that. If you like my content, please like and subscribe and hit that notification bell, and you'll get these awesome new videos. Stay safe out there, and thanks for watching.